So, friends, I'm delighted to have you all on board for a very, very important topic and discussion on the Digital Personal Data Protection Act. And I'm delighted to introduce the panel, partner at TriLegal, Shivangi Nadkarni, the Chief Executive Officer and founder of Arrka, which is a data privacy company. We were to have Shri Sharma, the Secretary MeitY, who was to be here, but he has been suddenly called over to the Prime Minister's office for an important discussion. And he has deputed Shri Deepak Goel, Group Coordinator for this Act, who has been involved with the creation of this Act as his representative. And so all these people here have been very actively associated with the Digital Personal Data Protection Act, which has been notified in the Gazette on the 11th of August this year. As we are all aware, digital data constitutes both the foundation and the superstructure on which digital transactions are developed. Record keeping and management of data is critical and sensitive as they affect personal privacy and the safety of our digital life. In the famous Justice Puttaswamy case in 2017, the 9-judge Supreme Court bench gave a unanimous answer with conclusive and unambiguous determination that the right to privacy is a part of fundamental rights which can be traced to Articles 14, 19, and 21 of the Constitution of India. The Digital Personal Data Protection Act flows from that mandate and direction. So now we have a statute with a framework and with a definite compliance obligation framework and with very compelling penal provisions. At the outset, I wish to congratulate the Ministry of Electronics and Information Technology. And it's a pity that Sharma Saab has had to go away, but his representative Deepak Goel ji is here, and I congratulate the department for the stellar achievement of getting this act together. It was the need of the hour, and it places us, even though which was necessary, but we've done it. Let's give them, the MeitY, a big hand. Congratulations, MeitY. The key objective of this act is to safeguard the citizen by protecting their personal data while allowing for it to be accessed in occasions of exceptional need, and we'll come to that, and to balance the rights of the individual with the functional viability of data fiduciaries or corporates, custodians, and dealing with that data. The key terms in the Act, which are simple, are data principle, which means the person or the individual or the owner of the data fiduciary, who's the custodian and processor and user of that data, or who's applying that data to users. The significant data fiduciary, in case the company is large and the amount of data and the scale and volume of data is enormous, then the data fiduciary is replaced by the term the significant data fiduciary. The data protection officer, who protects the data and interacts with the client or with the data principal on behalf of the data fiduciary. The consent manager, this is a new terminology and has legal implications, where the consent manager is somebody you can repose your trust in and who will be your somewhat of an attorney for you for dealing with your data. And there is the Data Protection Board, which is there to safeguard your interests as a data principal and which has the powers of the court for undertaking for implementing the penal provisions. The Act is simple and brief, with lots of examples that make it rather lucid. No civil court is permitted to entertain any suit in respect of any proceeding or decision of the Data Protection Board. Like with every new law, even though it has been deliberated for many years since the Shri Krishna committee, there are, of course, anxieties and concerns, and that is why we are here today to discuss this. And we have, once again, a very eminent panel of luminaries who are involved with this act on various sides of this act. We have Mr. Rahul Matthan, who is a partner with one of the top law firms, TriLegal, Shivangi Nadkarni, who is the CEO and founder of her own company, Arrka Capital, which deals with data privacy issues. And we have Deepak Goel Saab, who represents the Ministry of Electronics and Information Technology. Before we start, a quick word about Cunsult, which is organizing this webinar. As the founder of Cunsult, it's in a very nascent stage still. We provide a platform where instant advice and guidance can be given to people who need that through experts. We have a large panel of public administrators and experts who can be contacted for consultations, guidance, and advice. On any public policy issue, you can reach us through the cunsult.com. And Cunsult here is written as CUNSULT. I'll quickly... okay. So this is the Cunsult site. Yeah, so we and basically you can reach us quickly at any given time, and we can answer your queries, and we'll get back to you on the best possible thing that we can do for you. We organize speakers, we will advise you, and we'll take that forward. Now I'll request each of the three luminaries here to offer their opening comments to set the tone for our discussion, after which I will pose a few questions, and then we will have a question and answer session. Deepak Goel Saab, a few words from your side, and then I will take it on to Shivangi and then Rahul. Goel Saab.
Thank you, sir. This Digital Personal Data Protection Act now. So we have been calling it as a bill for last 6-7 years. Now it has become an act given assent by the Parliament and then assented by the President. So we are here. The act is here to protect the digital privacy, provide the digital protection to our digital data, and we are giving some rights to the individuals for protecting their personal data. And we are just basically trying to enable the fiduciaries who needs to process the personal data, of course, on some lawful purposes. The very important part is that it is giving an extension to the right to privacy, means which was entrusted to us through the Swami judgment. So we are providing some new rights to the users who are basically using those digital services. So I will not go into the main points. The core objective that when the bill drafting was going on, the core objective was we just try to introduce the protection with minimal business disruption, means basically the ease of living and ease of doing business were also always kept in mind when this particular bill was drafted. Then we are just trying to say empower our digital economy, and then we need to say promote the digital innovation ecosystem, or other than digital also innovation ecosystem, which uses our data. And then the core point is that what were the main basic principles that we used while this particular act was in the draft mode. These particular principles have been applied across the geographies, and we are no different. But even then, I would just like to elaborate a bit, means a single 7 statements. We focused on consented, lawful, transparent use of personal data. The next point is that it is using the principle of personal purpose limitation, which says that the data should be captured only for that specified purposes. Then the next point comes in the data minimization, that we are collecting only that particular necessary data which is required for that specified purpose. Here in this particular bill, there is a provision that if somebody is just trying to capture the data other than the minimal data, then it would be an infringement of that particular act. this particular aspect, I don't think anywhere in the world this particular aspect has been imbibed. Then the data accuracy and the Bayesian rights to the individual, they are of course the integral part of that particular act, our act. Then we have a storage limitation component that we need to store the data only as our law permits. Law means not only this act, the other acts also of the country also. Then the data fiduciary has to apply for the reasonable security safeguards to that particular data set to which he is trying to control. The seventh and the last point is accountability of the data fiduciary about the penalty, about the breaches that happens that for the data it is having, and then the breach adjudication and the penalties. So these are the major 7 principles that we have kept in mind while framing that particular the act. One particular thing, one more thing that we tried to include in this bill was the inclusivity of those particular sections of those society which are sort of, we say that they have not been given any rights. So notices and consent, we have tried to say we have given an sort of an empowerment to them that notices and consent are to be given to the data principals, that is the citizens, in those particular 22 languages which are enshrined in that, I think 8th schedule. Rahul can correct me if I am wrong. So, and one more thing that is very particular, that in all our earlier acts in the passed through the parliament, we have been using the word he, and in this particular act we use the word she. Shivangi can vouch for it. And moreover, if we will go to the definition of she, it doesn't only include he, but it also includes the third gender. Means we have given it very purposefully, irrespective of the gender. Means any scale, means everybody's data we have tried to say, give it a sort of a reflection that it gets protected. Then
very good. Yeah. Yes. Something else, Goel sir?
So there are more things to say, but I think I can pitch in later if time permits.
All right. Shivangi, you've heard Goel Saab also. Please do offer your preliminary comments on the Act and how it applies to citizens, to whatever you pursue as a passion and as a mandate of your shareholders or your stakeholders. Please tell us about that.
Thank you. Thanks for inviting me here, sir. I think this is an act that we've been waiting for a very long time. I've been tracking this right from the AP Shah times, so it's gone through a lot of sort of cycles and changes. And finally, the version that has come out is absolutely commendable. Of course, I'd speak about it from wearing an organizational perspective, from an implementation angle and so on. I think a lot of innovations, innovative terms, stuff like even the terminology, right? Data principle and data fiduciary, it's the first law in the world to use that, which puts, vis-a-vis what the rest of the world uses as data subject and controller. It has flipped the equation, so to say. And several new things like, the fact that we've introduced duties also. So it's like, as a citizen, I'm not just entitled to rights, but I have certain duties as well, right? So some of these things have been very innovative. I think on the ground, if I were to look at an organization that has to now cater to, all the citizens who come under the ambit of this, basically come under the personal data of citizens that comes here. I think the crux is, I don't know if as yet what we call the penny has dropped, right? And the crux of this, which Goel sub emphasized, is the fact that you cannot take personal data for granted anymore within an organization, which is a complete change from what has been the practice till now. The practice till now has been that as long as I keep the data safe and I ensure it doesn't get into wrong hands, which is the security safeguards aspect, within the organization, I can use the data any which way, right? Which is suddenly you're now entering an era which says that, hey, you cannot use the data any which way. You have to have a strong purpose associated with all the data that you collect, have a process, have a clear processing associated with it, and ensure that the processing matches a legal basis, which basically means I just can't collect as much as I want, and then once it's in my custody, I can't use it as I want, I can't share it as I want. Now, this is a complete flip in terms of mindset, in terms of culture, in terms of everything that an organization at a business level has been working towards. However, on the ground, if you see discussions, they tend to be more focused on continuing about how do you increase the security of the data, which is critical, which absolutely you have to pay attention to, but not missing the main point, right? So those are some things of concern. I think the whole, even the security of security safeguards itself is a big thing, because the very fact that it brings in, breach notification, which means that if I have had a security breach, I need to report it to the board and to the the affected individual. That itself means that I need to up my security game as an organization, which is again a very big thing, right? It needs to be done. You can't afford to have this lackadaisical attitude towards security as well. So I think overall, that's where I feel it brings a lot of power. But as a very senior legal law expert was telling me, he says it took a while for, let's say, an act as powerful as RTI to seep in, right? And similarly, he felt that something like the DPDPA will take a while for the impact to seep in into the overall psyche of the country. So, but I think it's a great start, and most laws take a while to find their way and into the ground. If we see a lot of acts which have been around for the last 6, 8, 10 years, even now we see clarifications, guidances coming out as the world evolves. So I'm sure same thing will happen with this as well. So I think that's a little bit from my side, and happy to chip in later as well.
Sure. Thank you, Shivangi. That was useful. Rahul, can we have your opening comments, please?
Yes, and thank you for inviting me. I just to echo the sentiments of everyone else, have probably been waiting maybe even longer than Shivangi, because the very first draft I was involved in was in 2011. That was before the AP Shah committee report. So I have seen many versions of this law, and I had almost given up hope that we would get a law. So no one is happier than me to have this law on the books. And as a result of that, I have a bit of a perspective on how the law evolved. I think the very first draft that we worked on was a very simple draft, and we are now back to a relatively simple draft after having gone through a phase of, I think, increasing complexity. So I would actually like to commend the government on actually withdrawing the draft, the draft that had, I think, just because we were trying to deal with so many stakeholders, got to my mind more and more complex, and brought out this draft, which I think still captures all of the provisions that I would have liked to have seen, with some exceptions, and I'll just get into that as well. But does that in a very simple way, which I think, as Shivangi says, this is a even though we're the last country in the world, we are a country with actually very little experience of what it will take to work a data protection law. And by work a data protection law, I mean just the mechanics of having companies comply with all the things that are upon them. And if we had put upon companies a burden which is as onerous as the GDPR burden, which everyone says is what we should have, that's the global standard, we would have actually failed. We would have had companies not complying, and it makes no sense putting in place a law that everyone is not able to comply with from the beginning. So I like the fact that we have gone with this simpler version of the law. And I'm sure that as time passes, we're going to make more and more provisions that are appropriate to what is happening on the ground. So that's I think the overarching comment that I would make, and I'm saying that upfront so that some of the comments that I make about the things that I think are missing and I would like to have seen in the law are taken in the right context. I actually like, I'm going to say 80 to 90% of this law, but there are some things that I wish had been included. And one of the things that I think is missing is the right to data portability, which is a fairly standard right around the world, and something that I think is perhaps very, very relevant for a lot of the things that we're doing in India. And just so that everyone in the audience understands what I'm talking about, the right to data portability essentially says that if a data fiduciary has my data and I am, I want that data or I want to transfer it to another data fiduciary, I have the right to ask them to port the data. Essentially, if I have information, if one lender has some information of mine, but I want to give it to some other lender so that maybe they can give me a loan, I have the right to take that data from one to the other and get that loan. And this is a right that in explicit terms is not there in this draft. What we do have is the consent manager framework. And the consent manager framework is very relevant in this context because if you look at what's happening in the financial sector, the account aggregator framework, account aggregator is the consent manager in the financial sector, is actually doing exactly this. They are doing this data portability through the account aggregator framework. That is the consent manager framework, which has been given legal status under the data protection law as well. But I worry that entities that are not subject to the financial sector regulator may miss out on this right to data portability, which is something that I think that all individuals would like to have. And then I think, to be completely clear, I'm very happy with the way most of the other provisions have been drafted. But I think, right towards the end, there was a new provision around blocking orders, which I was wondering whether we needed in this law, particularly since I'm quite sure the Digital India Act, just like the IT Act right now, has these blocking orders. So other than these two comments that I had on the law, I'm actually quite keen to see now how this law, how it evolves into something more in detail as we see the regulations coming out, as we see the Data Protection Board being created. I think we all tend to think that the coming into effect of the act is where it all ends, but that's really where it begins, certainly for the government, because you do have to now set up the regulator, which is the board. You have to set up all the rules and regulations, which are going to give you the details of many of the provisions. So there's a lot that's left to be done. And just one point of slight contradiction to Shivangi. I don't know how your clients are reacting, Shivangi, but I have, today itself, I have done already 2 webinars on the data protection law. Yesterday, I did 2. My clients, can't get enough of these webinars. They're asking for more and more sessions with them to explain to them, how this will affect them. I think, yes, maybe the penny hadn't dropped. We've been waiting for this. I've been waiting for this for over a decade. And I would have thought that by now they would have learned all of these things. But no, the moment the act was notified in the Gazette, we've been inundated with requests to try and explain how this means. In fact, my firm has every day since the act has been enacted issued advisories to clients in every sector, and we continue to do this to say, if you're an employer, this is how the act will affect you. If you're a social media company, this is how it will affect you. Because I think it's important to actually put yourself in the shoes of companies that now have to comply with these regulations and say, this is what you need to do. And I think just one final comment. I think one thing which I'm not, I'm neither here nor there about, but I just want to point out that it is unusual in data protection laws to have this sort of a provision, and that is the data retention provision. Data retention restrictions are standard in data protection laws around the world. And retention restrictions essentially say that you can't retain data for longer than you need to in order to serve the purpose for which it was collected. But in most laws, they leave it at that. In the Indian draft, in draft now, I keep saying draft, like, I just used to saying bill and draft for 10 years. It's very difficult for me to think of this as an act in a law right now. But in the law, this is the first law in the world that has a provision which seems to suggest that there will be a time period that will be notified, after which, if the data has not been used for a particular time period, used either by the data principal, as in the data principal asks for it or accesses it, or the data fiduciary in providing a service, then the data fiduciary is actually required to delete that data. Now, that puts a very heavy burden on companies to try and set up a mechanism to understand. Of course, we don't know what this time period is, but let's, whatever the time period is, even if it is 12 years, you need to have a track of how long it will, if the data remains unused, and after that, you've got to delete it. In every other jurisdiction, you have the ability to say, to sort of describe some broader purpose. At some point in time, I would provide you this service, and so I still need to keep the data. But in the Indian law, we have this strong retention restriction. Do I like it? I mean, as a data principal, as someone whose data is in various places, of course I like it, because I would like them to sort of delete their data after, not keep it forever. But as companies think about this is the one thing that a lot of them are saying is going to be a difficult thing to implement. But if they do manage to implement it, I think we're going to have one of the more advanced data protection jurisdictions anywhere in the world, because we'll have frameworks that will, just by the nature of the regulation, ensure that not more data than is absolutely necessary is in the hands of the private sector. So I will pause here, and happy to answer any questions and sure, participate in the conversation.
Yeah, sure. Very good, Rahul. Thank you very much. That was extremely useful. Now, a couple of questions before we throw it open to the audience. Shivangi, that's for you. How will the data principal or data owner get to know if their data safety has been breached if they are not alerted for some reason, because of oversight? And even if the data protection board doesn't get to know about it, so can a third party intervene? And do you think that's a good thing to have third party intervention? How do you view that?
Well, first of all, if there has been
like a PIL,
Yeah, so if there has been a breach and if the company doesn't know about it, but a third party finds out, which doesn't happen too often, because first the organization is expected to find out, but sometimes outside parties do know. In which case, how it will work in the legal framework, I don't know. I think Rahul will be able to give a better insight on that. But basically, I think if that happens and if they report to the board, I'm sure some sort of a mechanism will be worked out. But if a organization detects the data breach but does not report, I'm sure there are other penalizing actions for that.
Rahul, would you like to comment about this thing about an individual not getting to know that his data has been breached, but somebody outside being aware, and can that somebody go file a PIL or an equivalent of a PIL to the data protection board and get them to intervene?
So typically, that's not the way, as Shivangi says, that's not the way this happens. I think the way data breaches happen is, quite often it is, in fact, a third party. It would be, some sort of a person who on the dark web sees that all this information is out there, and they rarely report it some white hackers will report it first to the company and then in this current context before the Data Protection Board to CERT-In, because right now already a reporting obligation to CERT-In under the IT Act, and these sorts of reports happen actually quite frequently. If you're an ethical hacker, you will report it to the company, because rather than going out and scaring people, the company sometimes has the ability to stop these attacks. And I think in many of these situations, the most important thing to do is to actually reverse the effects of that data breach, as in plug the vulnerability in the servers, make sure that data can't be siphoned out, and things like that. The second thing is that if it has been siphoned, to tell all the people whose data is at risk that this has happened, so they can as quickly as possible go and change their login ID, because usually this information is out on the dark web, and anyone can pick it up, and if it's bank information, for example, they can pull money out of your bank and things like that. So the two very important things are go to the company and get the company to shut things down, and secondly, actually tell as many people who are affected, and that actually is what is prescribed under this new law as well. It's an obligation,
Yes.
A reporting obligation, and I think and after that, of course, we can look in to see whether this is something which was a criminal breach or something like that, whether there was someone involved. But I think it's absolutely important to get these two things done very quickly, because the danger to individuals' personal data, financial information, all sorts of things is very, very high in a lot of these situations.
True. Except that, the number of such cases that are going to be reported now are going to be enormous and astronomical. And even now we find that data breaches, it's very difficult for the police to either keep track of them, or even if they log in, to follow up and to be able to take it to a conclusive sort of this thing. So, with the Data Protection Board, you might just have a situation where the board is active, but the agencies themselves are unable to do very much. So the responsibility of the companies is going to increase manifold.
Correct.
And Goel Saab, this is tell me this that data storage in India was a very prime issue, and you all have tackled it through this act, if I can understand, saying that you can determine, the government can determine which country the data is stored in and where it is not. But you have given a proviso that if the data is required for a legal purpose, then you can skip this necessity. So do you think that companies can get around and bypass this by using the support of their parent states to say that they required the data for a to comply with some legal provision, and thereby skip this mandatory requirement? If you say, for instance, that a data should not be stored in country X, then they use this provision to bypass this.
I think, sir, as a good Samaritan company, every company would like to abide by the law of the land where they are operating. And if we just go by the applicability of this particular act, so we are saying that any data get processed within the territory of India. This is the primary thing, or any paper means non-digitized data, and then if it gets digitized subsequently. So our territorial jurisdiction gets extended. So one thing is this. Another is that we will be restricting the countries to whom the data cannot be transferred. So that particular thing, if somebody is processing our data, means the data of the here in our country, and the government say restricts restricts a country that there the data cannot go. So it would not be, it cannot be transferred out of it. So if we are just if companies are trying to say that unless notified, we can transfer it to some other jurisdictions. So they will have to take the consent of the individual that I need to take that particular data outside the country. So I think those particular things will evolve over a period of time. And then I think the consent of the individual would be very, very important.
Yes, of course. It's very, very important, and it's not going to be easy for companies to deal with so many this thing. But I guess that it will be mandatory, and it's in the interest of the individual data principle. Thanks, Goel Sahab. Rahul, with this increasing responsibility of and beyond just moral accountability, but also the physical part of it, in terms of disclosures and communications, notices in many languages, old purpose versus new purpose, notice versus consent. Do you think this might even provoke some kind of a data activism in the days to come, to blackmail companies and to this thing? I'm not, this is beyond the act. I'm looking at the larger picture as we go down. Do you think something like that might just happen, or do you think we're all in safe hands? And because ultimately we might all be working for companies or being associated with companies, so we are more than just individuals. We are also entities in a larger world. So, or do you think this is all hunky-dory and the chances for misuse are not there?
Yeah, well, I mean, I think we've got to sort of situate this in the fact that one, India is a highly digital country. We've been digital for over a decade and a half, and particularly now, when you look at over the last 6 months, we've seen this big push around digital public infrastructure. The whole world is applauding India's achievements in digital public infrastructure. That's all coming from the fact that maybe in the last 5 years, India has, all of the country, even down to tier 2, tier 3 rural areas, everyone is leveraging digital in a very powerful way, which means that there's a lot of data out in the country right now. And that all of these concerns that you have, blackmail and even just spams and people manipulating data to take advantage of other people, that's with us. It's been with us for a very long time. And you've got to understand that it's been with us in the absence of this law. So for over a decade, we've been managing without this law, and there've been a whole number of incidents that keep happening. So I'm actually very hopeful, because I think what we now have is, we have, in addition to all the ways in which we've coped with these digital challenges. And you may say that we haven't done so well in some cases, but I would actually say that considering the fact that we don't have a law, we've done pretty well to manage all of these issues with our traditional, IPC and various basic laws. We've applied them and brought people to book. With this law and with the new requirement, one of which I pointed out, which is the retention restriction and things like that, I think things can only get better. Because in the past, companies and this creation of data and proliferation of data was happening without check, because none of these notice restrictions, which means that you have to say before you collect and use the data, what data you're collecting and what purpose you're using it for. You can only keep it for as long as it's required to serve that purpose, after which there is a mandatory deletion obligation. Companies never had all these restrictions, and so there was just this vast proliferation of data. Now I'm hoping that once all of these are in place with penalties of up to 250 crores, companies are likely to think very carefully about violating these provisions. If that happens, we are likely to reduce the amount of data at risk. And that, I think, is
I must compliment the MeitY for being so bold as to, Goel Sahab, to be able to have penal provisions which go up to 250 crores. The first time I'm seeing such major provisions, and it's a nice thing, because the volume of data and the value of that data is so enormous that you all have chosen those figures perhaps quite appropriately and have thought it through. So just shows that
I was hoping it would be higher. I mean, 250 is $30 million around the world. It could be higher.
So there you are. So in the next amendment to the act, you could make it higher. Shivangi and Rahul, there are no exemptions that I see for startups and such like in the act, unless I've missed it. perhaps, and Goel Saab, are you aware of any exemptions that there are in the Act for or facilities for these startups?
Yes, sir. There are some exemptions for startups. Means that there are some provisions which will not be applicable specifically given for the specifically as far as the rights are concerned to the individuals. I think
which section? Because I couldn't locate it.
I think
Section
section
17.3.
17.4,
sorry. No, 17.3.
17.3 or 17.3. Yes.
Okay. Okay, so there, yeah, startups are indeed mentioned there. So you do say, yeah, except that it's very numerical in terms of this section and that section. But yes, the word startups is there. So that's a very happy thing that startups do have some exemptions. That's nice. Rahul, do you think this whole industry of consent managers is going to be another proliferating area for, for people to start preparing for, like notaries, except that they'll be more exalted data managers? Or do you think it'll be law firms who will have this task, or can individuals also prepare for, pass some basic examination and something and become consent managers? But before I come to you, Goel Saab, I mean, what was the thought behind leaving it open?
Sir, consent managers are basically, they would be primarily a data fiduciary who is just simply having a plethora of the data of individuals. My personal data, your personal data, means it's a sort of you can say initially they would be an aggregator of the individual's data. Then they would be upgrade themselves to the consent aggregators for different type of business entities like B2C or say telecom or any other type of business. So they will be sort of an intermediaries acting as a data fiduciaries, not actually intermediary in the definition of the IT Act. I am just taking that particular word back. That IT Act intermediary definition is something different. But as an intermediary in this total business. And just to complement what you say, sir, I think there would be quite a jump into those particular startups which are coming as an techno-legal framework. Means this consent manager would be a sort of an amalgamation of highly technically resourceful companies and some legal luminaries. Means I think the two panelists, Shivangi and Rahul, they are a perfect match for a consent manager.
Great. I can see the smile on their faces, and many other such consent managers would be spawned. Before I throw it open for question and answer, Shivangi, I want to know from you, based on your analysis of this act and what you've been pursuing so many years, are there any major areas that have been left out? Rahul did mention some, but according to you, in terms of protecting the individual, the rights of the citizen, does the Act cover it comprehensively, or you think there are some key areas which lend themselves to A, lawmaking, and B, in terms of future subordinate legislation?
Nothing major that I can think of that has been left out, but I think downstream we will have to think through many of the nitty-gritties and details, like for example, Rahul was talking about retention of data, right? So let's say we take the banking sector per se. They have to look at retaining data, yet there are anti-money laundering laws, there are other laws that require retention of data. So at the granular level, there needs to be some sort of standardization within sectors as to really what data needs to be retained, what data needs to be erased, when there is a right to erasure, and so on. So those are the kind of downstream specifications, detailing that will have to emerge. Maybe in some cases, the regulators may have to step in to give guidance, maybe sectoral regulators. In some cases, vertical organizations may need to step in. Otherwise, it will be like every entity trying to figure out things for themselves. So But at a overall level, I don't particularly see anything that is of concern. But then, as I said, this is something which probably someone who's, like Rahul, who's from the legal or the policy space, will be in a better position to sort of
Sure.
comment.
Rahul, you did say data portability is one key area which you would have expected to be there, and which is significant and important. Data retention. What else can you think of which would have made it at par with the best such laws anywhere in the world?
So, I mean, just to be clear, as I said, the best possible law is the GDPR. I think we don't really want to be on par with GDPR because, in my view, GDPR is getting to be extremely complicated and cumbersome, and particularly for a country that's starting out, it's not appropriate. But having said that, the one other provision that you typically see in data protection laws around the world is this right to be forgotten. And we don't have the right to be forgotten. And quite frankly, I'm just saying we don't have it. I don't think we should have had it. It's a sophisticated right. It's a right that an advanced data protection jurisdiction should have. So unlike the right to data portability, which I was a little disappointed that I didn't see, I'm not that disappointed that I don't see the right to be forgotten because, we have the right to erasure, which is essentially I have a direct right to erase information after it has served its purpose. The right to be forgotten is a much more sophisticated right. It is a right to have data forgotten out of search engines and things like that. I mean, arguably we need that as well, but let's get all of these the plumbing right for the basic stuff, and then we can go to the more sophisticated provisions.
Sure. I'll now throw this open for question and answers. Please raise your hand if you have a question, or mention it in the chat room, and we will take it from there. So it seems that the panelists have really clarified everything so well that it's left everybody completely fulfilled without any significant questions. So, yeah, here is a question which has been asked. How the individual to individual relationship about data will be affected by coming into this act? How the individual to individual relationship about data will be affected. Goel Saab, would you like to attempt this, or shall we pass it on to Rahul?
Well, I think the applicability for the personal usage is not there. Means if we go to the section 3, this is not applicable to the personal data processed by an individual for any personal usage. So if I am collecting, I am talking to you, I am giving you my name, my
correct.
So it's basically I'm giving you for a personal purpose, and you are not going to use it for any commercial purposes. So now we are taking it out of the ambit of this bill.
Okay.
I think Rahul being a legal luminary can add on to
that. That's absolutely correct. See, I think the point of this law is to address data fiduciaries. Data fiduciaries are typically corporate entities. If I collect your name and phone number for a party of the year that I'm having, that's not within the data protection law because that's a personal or a domestic purpose. So I wouldn't worry about individual to individual. That's specifically.
Yeah, that's pretty much answered. So the next question is, I have a question related to data principal nominee mentioned in the law. So Amit Rapate, would you please ask this question? Amit Rapate, yeah. Amit, please go ahead.
Yeah, actually there is a mention in the law. So we can just take a nominee. So in case of data principal death or incapacity. So can you please elaborate something on that?
Rahul?
Yeah, this is. I mean, I think it's essentially saying that we have a lot of personal data in the hands of various companies, data fiduciaries, etc. What happens if we die, or if for some reason we are unable to exercise our rights? In those instances, I think what the idea is that we could nominate someone. Obviously, we'll see the details as to who it is, how this nomination has to happen, so that after we are no longer in the capable of exercising our rights over that data, all the rights that are there in the act, that the nominee can do it on our behalf. This also is a relatively new provision. I don't know, Shivangi, you've seen laws from all over. I haven't seen nominee provisions in too many other laws. So it's interesting. I don't have too much experience from a comparative study of different laws as to how this might play out, or even if there was really a strong need for it. But it's interesting that it's there, because we're going to now have to put in place some mechanism to figure out how to work this.
Thank you very much.
So you're speaking on mute.
Yeah, there's another question. B2B data protection is understandable. Nag, I don't have the full name, asks, and what about B2C data protection? So what aspect of B2C, Nag, would you unmute yourself and please ask the question directly? Nag? Okay. So
I mean, maybe I can just attempt an answer.
Yeah, sure, Rahul.
To be honest, I think it is only B2C data protection that the law covers. B2B, because B2B is business to business, and if there's a business that provides personal data about itself to another business, first of all, it doesn't qualify because it's not personal data. That would be covered under the law of confidentiality, where if there's information that's shared between companies, that would be covered under the whatever the laws of confidentiality are, which are typically laws that relate to contractual protections for confidentiality. All of this act is actually designed for B2C. Businesses are typically the data fiduciaries, and consumers are typically the data principals. And so you are looking to implement B2C data protection, because businesses are required to protect the data of the consumers that they are holding.
I just want to add to what Rahul just said on this. So, so while the B2C company is the fiduciary primarily, but because most fiduciaries work through a huge network of vendors and third parties who are their processors, and there's a mention of processors in the law as well. So, because they are accountable and they are outsourcing data, transferring data to third parties for work, which is a B2B transaction, they are expected, and this is a norm followed worldwide, where they will put in the kind of controls that they have to exercise, further pass it on via contracts to their third parties. So if you're a B2B business servicing a large organization, you may not have to directly comply with the law, but you will have contractual compliance which your customer will mandate from you. So indirectly you may have to comply with whichever is the data protection law. So you have a number of ITS companies in India today who are B2B, who are complying with GDPR, who are complying with various other laws in the world, simply because it comes to them through their contracts.
Mr. Hem Pandey has a question, and I'm reading it out. It's a rather long question. India is on average level on regulations, but poor in implementation. And I think if it's Mr. Hem Pandey, the civil servant, then who knows it better than a civil servant? And he says, data protection will see the same fate, ? Or do you think we will improve? So this is, I will not ask Goel Saab about this, but Rahul, you and Shivangi should certainly offer your views. And as a former civil servant, please don't make it very, very negative for civil servants.
No, I'm very optimistic. Look, there's always things to improve, but I'm very optimistic. I think this is a simple law. It sort of starts off on the right foot. I can only hope that we will continue along this path and come up with I guess simple regulations. And as long as we have simple laws and simple regulations, then enforcement is easier. It's when we start making complications and we start, having the earlier draft had 14 different types of things to be notified. This draft has 2. And so when you make things simple, you remove the opportunity for rent seeking and all of the other things that come in the way of good implementation.
Absolutely. And the simpler the act, the better it is, because it allows for more malleability in the regulations, because the rules will be made by the at the ministerial level, and they can always be modified. But if there is a provision in the act, it becomes far more complicated because it has to go to Parliament for every small alteration. And I can give you several good examples of that some other time. There's another question which Ashish Singh asks about proprietorship firm as an individual. So again, I think, Rahul, that you already answered that this is basically personal data protection, this thing, and we're talking of individuals and not a B2B sort of scenario, until and unless directly the personal data of individuals is breached, in which case would there be a liability for, say, for instance, a firm, a software firm gives its work to a developer, and the breach takes place at the level of the developer? Can the software firm because after all, ultimately it is data of individuals which is with the software firm, but it has been breached at the level of the developer, and it becomes very clear that the developer was negligent and allowed that to happen. Then can would routine IPC breach of trust and things like that fall in line, or would that be also covered in some way by the Data Protection Act?
No, I think it's important to understand that the exemption in Section 3 is for processing for personal or domestic purpose. Now, if you are processing for a business purpose, then you absolutely will be liable under the Act. So when I gave the example of me processing data for like a party or something like that, that's a personal or a domestic purpose. But if you are a proprietorship firm, and please understand that some proprietorship firms are actually quite large. They're large organizations. They just haven't set themselves up as a company or something like that. You can't get away if you're running a business, and that business is actually like a software development business. And just because you're an individual who's running it as a sole proprietorship, you can hold a lot of data of people and you breach it. You're obliged, because that's not a personal or a domestic purpose. It's actually a business purpose, and it would apply to you. I think it's just like if it's a small threshold kind of activity, yes, maybe there would be volume requirements, etc. I don't think just because you're a proprietorship firm, which is essentially there's one individual that you would escape. I think we need to look at the purpose for which it is being processed. And that's why when you say B2C, it's a business doesn't mean that it is a corporate business. It could even be a sole proprietorship business. But it's the B2B that, as Shivangi says, B2B, the only way it would apply is in the data fiduciary data processor relationship. And that's a completely different construct. But a sole proprietorship is a B2C and would be covered, in my view. I don't know if there's if MeitY has a different view.
No, we'll go along with that. Deepak Goel Sahab, would you say something about that?
Sir, I think we need to see the definition of data fiduciary very secondly. Means we say that it means any person. So person is a proprietary company also. He can be individual, HUF, firm, associations, means as we have in the Income Tax Act. and then who alone or in conjunction with other persons. So again, we are just combining one or more than one person, determines the purpose and the means of processing. So this is the keyword, sir. Determination and the means of processing means who is basically determining that this particular type of data would be processed. So if as a company, I am determining, so I am the data fiduciary who is basically taking all the onus of any type of mishappening, breaches covered in this particular act. And whether I am in conjunction with any other data fiduciaries, that's again the purpose of determination. Basically, the determining the purpose and the means of processing is the keyword.
Yes, yes. I think you've clarified it extremely well. We have another question by Mr. Mahesh Bagarwal. Is Digital Personal Data Protection Act, does it serve the common person's interest effectively? We've gone through this, so I'll skip this question for the moment. I think all that we have discussed so far, Bagarwal Sahab has broadly answered this. Gaurav Garg wants to know what will happen. I don't know what, he hasn't been able to spell out his question. Then Ruhi Sharma asks a question. Are there implications for when an organization is collecting and storing data digitally about vulnerable populations like children, especially when there are assessment scores and personal information collected to carry that process out? Shivangi?
Yeah, I think the law calls out children's data specifically, which is very commendable, and it has very clearly stated that you cannot, advertise targeted advertising to children, or to track and do behavioral profiling of children, which is very critical, because today otherwise that's quite rampant. So I think there's adequate. By itself, the law has enough protection for personal data, and these additional call outs for children's data is all the more effective to be able to give them extra protection that's required, which is very, very, very important. And because I think the advantage of the law coming out in 2023 has served the purpose that they were able to add it to the law. If you see the other jurisdictions, many places, they're now coming out with separate legislations or other frameworks for protection of children's data. It is one of the most critical and hotly discussed topics globally.
Yes, absolutely. Gaurav Garg wants to know, for a small business enterprise or a family business enterprise, what are the new challenges that there would be for aligning their existing data management practices with the Data Protection Act? Rahul, would you like to quickly, I mean, you have everything that you've said covers it, but still, would you like to clarify anything on that?
Yeah, I mean, I think the important thing for us to recognize is that all the big companies probably already have something like this in place, because if you're dealing around the world, you are subject already to GDPR and various other data protection laws around the world. Whereas small, family businesses that are very focused in India may not have given too much attention to this. So there is actually then a lot of work to be done. You've got to put in place your privacy policies, your consent management frameworks, your retention frameworks, all the things that we discussed, as you said. So, I mean, just to answer this question specifically, I think it, in many ways, it's easier for companies that are operating globally, because by virtue of operating globally, they've done this before. Companies that haven't had that will have to put all of these things in place, sometimes for the first time. And I think that is something that is non-trivial. And I think companies should give it due importance and seriousness, because it can be quite cumbersome and complicated. Shivangi does this all the time. She'll tell you all the various things that Arrka does as you go through these assessments for companies to figure out whether they're compliant with GDPR or not. We may not be as the onus may not be as high on us because this is a simpler law, but it is still going to be quite high for someone who hasn't done anything up until now.
True. Mr. Ved Prakash Chandan has a very interesting question, and I'm going to read it out verbatim. My question is about B2C situation. My housing welfare society has security cameras. The society records my movements. Can I protest and ask them not to record it? Shivangi?
Okay, so it's a bit nuanced. So today I'm sure that the reason that they are being recorded is for security purposes. Now the problem is now the issue is if as long as the data is used for security purposes alone, I think it's fine. The problem arises is when the data starts being used for other purposes other than the security of the individuals. When there's what is that creeping, purposes get added on is when problems start. And today, there is no way to figure out, or there is no control to ensure that it doesn't get used otherwise. Now, whether at all to use it for security purposes or not, I think maybe taking specific consent for that may help. Whether there's a question of opt out or not, I don't know. I think that's something which probably Rahul will give a better answer for.
Rahul, would you like to say something about that?
Yeah, look, I mean, very interesting question. And look, I think your housing welfare society probably has some rules and regulations. I would expect that some of those rules and regulations may have said that we are putting up security cameras. That would constitute notice. If you look at the act actually has a provision for notice and consent given before the coming into effect of the act, the fact that you may have consented. Now I'm making all of this up because I really don't know what is happening in your housing welfare society, but assuming all of these things are in place, this is fairly standard. It may not immediately be a problem. This is putting aside the things that Shivangi said, which is if there's if the data is then taken and used for some other purpose, then yes, there could be an issue. But we must also think about all the other provisions. Like, once again, just getting back to the retention restriction provision I had. If the purpose is security, there should be no reason why they should be keeping this data forever, right? So, you need to have data deletion sort of rules in place in your welfare society. So, I don't know, let's assume a week is reasonable, but why would you want to keep this data for longer than a week? If there's a theft or there's some incident that's happened, it should have come up within a week. So I think there are these sorts of things, new rights that you have now that the law is in place, that you can go back, even if there is this notice, and ask these sorts of intelligent questions. I would say, just protest for security. They'll probably say, find another housing welfare society to live in, because all of us want this and we can't turn the camera off whenever you're walking. But I think there are these sorts of, that's why it's a nuanced question. As Shivangi says, other people may want it and you're living in the welfare society, so it may not be possible for them to switch it off just when you're walking around. But you get the point. I think as long as there are some there's some balance in the way in which they work it, and now you have actually a legal lever to go to them and tell them, look,